Good afternoon. I'm Dr. Liesl Bryant, and I'm one of the risk management advocates for the Trust. And I'm delighted that you're able to join us today for our 30th Risk Management Roundtable. As a Trust policyholder, most of you are likely familiar with our risk management consultation service, the Advocate 800 program. It's one of the many benefits our policyholders receive through the Trust. I'm one of the 8 advocates, and I'm excited to be joined by 2 of my fellow advocates, Dr. Dan Taub and Dr. Stacy Larson. All right, so let's go ahead and get started. Thanks, Dan and Stacy. Glad to have you here today. So we're going to start with 4 topics that, as you both know, we've been getting lots of calls on, and the first of those topics is AI. So Dan, I'm gonna turn this one to you. And the question is, can we use AI or artificial intelligence in our practices? And if so, what are some of the initial considerations that we need to think through or work through before we adopt that or make use of it in practice?
Yeah, and that's a question, as you know, Liesl, we've been getting a lot for good reason. And I think that one way I would reframe that question is not whether can I use AI, but under what conditions. Because AI has become so prevalent that we find ourselves actually using it, sometimes not even knowing. Artificial intelligence, also to begin, is interesting because it's been defined in a variety of ways. There's some disagreement, but the areas of agreement are artificial intelligence is a non-human device that is often operating without independent input from humans. And those devices learn, problem solve, achieve goals, as Manning a few years ago said, appropriate to the context in an ever-varying world. These devices perceive the environment, adapt to it, form knowledge representation, as in ChatGPT or Copilot or Gemini. They can plan, they can make decisions, they can make things appropriately. There are many ways in which artificial intelligence has, one of the descriptions, it's been a tsunami in the past couple of years that I think many of us have experienced. And it comes also in different forms: self-driving cars, the online ChatGPT, large language models, even the autonomous content recommendations. For example, when you do a search on a search engine, you'll often nowadays get a brief description of an answer to your question that's generated by AI, even if you haven't asked for it, okay? And for psychologists and other mental health professionals, we have been inundated the past 18 months or so with AI options for practice. Record keeping, session summary notes, report writing programs. There have also been an increasing number online of chatbots like Elomia, Wobot, companion bots. Those have also become quite common, not without controversy, of course, as many of you know. And what we're going to see, I think, in mental health, but it's already happening in many areas of medicine, radiology, emergency rooms, are decision aids for diagnoses, treatment planning, and similar kinds of activities. So when we think about under what conditions can we use AI, given that it seems to be increasingly ubiquitous, there are some good initial questions to be asking oneself, but also asking of the programs and the material that we're looking at and considering, okay? Both to approach it ethically and also to approach the use of AI in an appropriately risk-managed way. The first issue, this won't surprise anybody here today, is one of competence. Do I know enough about this bot or device or program? And none of us are going to be, well, I shouldn't say none. There are probably a few people in this group today who also do programming. But even if you do, often we don't know exactly how the AI works. So what we do need to understand is, what functions does this program or bot serve? What are the data they collect? Where is that data stored? How is it stored? Which organizations have access, and how private is this? So the issue of functions and data security are very important. Now, these questions can be answered in part at least by considering two separate sets of materials. Almost every program that you will use will have a terms of service. It's essentially, when you're online, you click a link and you read to agree to determine what you are agreeing to by adopting the service, giving up your firstborn or something like that. And these agreements are especially important because they often tell us about how the system works, how it's used by the organization, whether they use the information that you and I provide to train their artificial intelligence systems. So very important to read. Unlike, when we click on a website or we download an app on our phone for personal purposes, we have to look at the terms of service for artificial intelligence. We also have to look at the second document, which is their privacy policies. This explains what information they gather, store, transmit. Is it anonymized? Is it released? And making it anonymous is actually trickier than it seems when you're using these often enormously large data sets, where when they're paired with what's called aggregator bots, which pull together information to try to identify particular people, it's not so hard to figure out the therapist and or patient's internet service number, location, even in some circumstances, their name. If the company is careful, the information they give you in the terms of service and privacy policy suggest that the data they develop is stored, say, locally on your computer, or if it's stored in the cloud, it's encrypted. They don't use it for training the AI so others can't get access, or they don't use it to give to business partners. You're on a much safer platform, okay, as compared to those that do use the information for training or store them in questionable cloud systems that may or may not be encrypted. Another component is to make sure that they will sign with you a business associates agreement, but be certain to review it for appropriateness. If the AI company has one to sign, read it. Does it comply with HIPAA? Get input. BAAs are pretty weak, and HIPAA is a pretty weak low bar protection, but it offers you some, and they're absolutely necessary. The other few things I'm going to mention before I stop include make sure you look at whether there's any research on the bot. Is it appropriate for population, the client you're working with? And have you engaged in a thorough and thoughtful oral and written informed consent with the client or patient about its use? And be sure to review all AI output. As we were having a conversation the other day, Lisa, you pointed out again, and I've read this a lot, AI makes lots of errors, has built-in bias. We cannot simply just assume everything it spits out is even close. Please do not use open systems online for any kind of information that could be identified about patients. AI online is a privacy nightmare. We don't endorse any particular platforms, but I believe AI for mental health professionals is going to become safer over time, basically due to market pressures.
Yeah, great. Thank you, Dan. You covered a lot. I know we'll probably clarify some of that more when we get the live questions, but that was great. Stacy, anything you want to add to that?
I would just reiterate the caution for right now, just making sure that you know what you're getting into, the competence aspect of it, because some people utilize it and they don't double check and errors happen. And so I think that I would back that up.
Yeah, and I think, and Dan, you mentioned this, but it goes to both of your points there. Educating yourself on AI, if you're going to use it, is really important. I read an article the other day that, people who really understand AI tend to be much more cautious because they know where the privacy risks are. People who don't understand it tend to think it's just fine. So, it's if you want to put it into use, that's great. I think there are ways to do so very carefully and thoughtfully, but really understanding where those risks lie, both so you can mediate them and, importantly, Dan, to your point, so that you can tell your patients where the potential risks are and they can give informed consent about whether they want to consent to that or not. So
Mhm.
yeah, very good points. I'm sure we'll get into more of this when we get some
Mhm.
questions.
Sure.
Stacy, let me turn to you with another topic we get many, many calls on, and that has to do with interjurisdictional or cross-jurisdictional teletherapy. So can you walk us through what are some of the primary considerations when that a clinician should think through when they're deciding whether or not to provide teletherapy across jurisdictions?
Sure. As Dan had mentioned, I think we all know that teletherapy has seen a boom as well due to events in our world and technology advances. And so we have more and more members, insureds that are wanting to attempt this. So some things to consider, some first aspects. It would be great to be licensed in both jurisdictions and be aware of the state laws in each jurisdiction. Not all providers are going to be licensed in that, and there are other options to do cross-jurisdictional therapy if you're not licensed in those other jurisdictions. But the licensure is the strongest protection that you'll have. If you are looking into working into another state, there's three options that I like to consider, or things I consider. There's temporary practice. So some states will allow providers who are not licensed in that state to practice into it temporarily. You would need to check the law of that state you are practicing into for this. For instance, California does allow 30 days annually. Some states, and I believe that might be one of the most broad ones, one of the most relaxed ones. Some states are very minimal. I know of one state that is a one-time, once in a lifetime that you can do this temporary practice. And some states don't allow it at all. So that's why it's really important to look into that state that you're practicing into and make sure that you follow whatever steps are needed if they have that temporary practice provision. A newer thing, which is not so new anymore, is SIPACT, another option for providers who are trying to do teletherapy across jurisdictions. So that's that cooperative agreement between states that allow providers to do that, to provide that telehealth across the different states and jurisdictions. So currently there are 43 jurisdictions that have signed on to the agreement. 2 states have the legislation pending. That, of course, leaves a few that are not either considering it or it's still in the works or anything like that. There is a process for applying to SIPACT, and ASPPB has some great resources. The Association of State and Provincial Psychology Boards has some great info on their website about SIPACT, how to apply, because you'd have to do that. What that does is it says that if you are in your home state, you can practice into other SIPACT states. So it gives you that ability to do cross-jurisdictional, does not give you the ability to practice into non-SIPACT states. I always want to make sure I clarify that. And then there's always a potential for a client emergency. Your client is on vacation or is in another state for a temporary time, and they have an emergency that they need to speak with you. In those instances, you might want to consider the ethics of providing or not sort of that cross-jurisdictional practice. You want to consider the best interest of the patient. Is it less risky to provide the emergency consult if the patient is out of town temporarily than it would be to say, I'm sorry, I cannot see you. I cannot provide that support. So it's something to consider. Now, if you do decide to provide cross-jurisdictional teletherapy, there are some other issues just logistically and practice minded that you would want to consider. Client appropriateness. So the ability to see clients through telehealth is a benefit for many. However, it's important to consider that not everyone is a good fit for telehealth. Technical issues, technical limitations, for one, like maybe individuals don't have the right technology, or maybe they just aren't capable of using technology in a way that would make therapy work. I think my mother, unfortunately, who is awful with technology. Not to say that older people are always awful with technology. And as well, you want to think that some clients are going to be better suited for face-to-face than for teletherapy for reasons of maybe it's a higher risk patient, or maybe it's due to their diagnosis, or maybe it's just somebody who needs the sort of the buy-in of having another person in the room with them. Is there a local provider that might be a better fit in those situations? You also, as Dan had said, competence. Want to consider your own competence. Do you know how the telehealth technology works? Do you feel competent to be able to provide those services? Now, if you go through all of those, then the next level of sort of considerations are then informed consent. You need to have a well-crafted informed consent document that speaks to the risks and benefits of telehealth. If you are seeing a patient in another state, that informed consent document should be relevant to their state laws. So this goes back to needing to make sure that you understand your own state's laws, but you also need to understand the state laws of where the patient is. So if you're seeing someone in Colorado and you're in New York, that informed consent document for that patient should be based on Colorado laws. You need to, and providers are responsible for maintaining the knowledge and complying with those laws, rules, and regulations, which could be mandated reporting, record keeping, et cetera, anything like that. Considering confidentiality of the telehealth, where is the client sitting during the session? Are they in a coffee shop? Granted, clients can kind of take their own risks on that as long as it's part of an informed consent, but I think we'd want them to be in a place where they might have a little bit more privacy, a little more confidentiality. The security of the platform you use, can you lock it so that others cannot access the platform during sessions? And you want to utilize a platform that is HIPAA compliant with a company that will sign a BAA, as Dan had said. Same with the AI. We really are trying to maintain HIPAA compliance. Some other logistical questions. How are you going to manage therapy across time zones? Across multiple time zones, as if it's international. I had somebody who wants to do therapy into, I think it was Singapore. So that was a very long time difference. So those are things that you need to consider on top of everything else. Emergencies. So we talked briefly about, if a patient contacts you in an emergency, what do you do? But if you're doing teletherapy, you really need to develop a safety plan with the client. It should include determining the number for emergency services, where the client is located, potentially an ROI for family members in case you're unable to reach the client or somebody that the client trusts. You need to know the local resources, where the hospitals, crisis units, providers. It's really important to have that plan for when you're working into another jurisdiction. And finally, the financial aspect of billing. So will insurance cover telehealth treatment into another jurisdiction? You may need to use different codes, modifiers. You would want to contact the insurer in advance to check with their policies, procedures related to billing for telehealth. Some risks that come up. While this isn't a super high risk endeavor, a state where you're not licensed could say you're practicing without a license and potentially notify your state's licensing board. It's a risk. You should be aware and take measures to be informed of state laws. There could be issues with malpractice insurance, which provides coverage for events that fall within the scope of psychology and the legality of psychology. And if you're practicing illegally into another state, that could potentially impact coverage for any claims that come through. With SIPACT, if a complaint is lodged against you, access could be suspended, and you would not be able to work through SIPACT into other states until that issue is resolved. And again, it's really important to have that informed consent and be aware of each state's laws regarding reporting, record keeping, access. I think mandated reporting is a big one that people don't realize how different all the states can be on what the levels are, what the types of, and who can be reporters or where to even report.
Mm-hmm. Yeah, terrific. Great point, Stacey. And again, super thorough. So thank you. That was great. Dan, anything you want to add on that?
Just a quick one to emphasize, Stacey, you referred to the reality that it really can have implications for liability coverage. If I practice illegally into Michigan or Florida and something goes wrong, I'm only covered when I'm practicing legally. So that's an important consideration for all of us as professionals. If you're a SIPACT member and you have a credential, you can practice into all of the other, because you have to be in your home SIPACT state, 42 states right now. But if you have a finding against you, your SIPACT credential can be removed permanently. And that's important to keep in mind. It's then beginning to be a big risk.
Yeah, I agree. No, you've noted a lot of good cautions there. I'm sure we're going to come back to some of those when we get questions, but I want to just dive into these last two questions for each of you, and then we'll turn to the live questions. So Dan, I'll start with you. And the topic here is coaching, which, as you know, we're also getting lots of calls on these days. So how is coaching different than providing, say, therapy or general psychological services? And if someone decides to engage in coaching, say life coaching, must they be licensed in the state where the client is?
Yeah. To understand, Lisa, the challenge in making this distinction, it's helpful to start with some definitions. The psychology licensing laws, most of which are grounded, at least to a good degree, if not completely, in the APA model legislation, basically governs two aspects of practice: what we call ourselves, licensed psychologists or psychologists, and what we do, our functions. So these laws control title and function, not just what we call ourselves. To give you one example of 53 or 52, including some other jurisdictions, the New York State licensing law basically very broadly defines the practice of psychology to include things like observation, modification of behavior, and here's the crucial language: enhancing interpersonal relationships, personal, group, or organizational effectiveness, and work and/or life adjustment, and improving behavioral and mental health. Many other states have similar kinds of terms that are used. And whether it's life coaching, personal coaching, to a lesser degree, but still to some extent executive coaching, the definition doesn't use the title. And while there isn't a focus on maladaptive behavior or psychopathology, as some psychologist licensing laws require, it's still, as you'll hear, pretty broad and overlapping with what I just read from the New York State law. The International Coach Federation defines coaching as a partnering with clients in a thought-provoking and creative process that inspires them to maximize their personal and professional potential, focuses on self-awareness and accountability, enables clients to take actionable steps towards their goals. It's not about providing advice or counseling, so they're trying to steer it away from that. Instead, equipping clients with the power to find their own solutions, with you acting as a guide. Note, these activities sound a whole lot like the expansive definitions in many psychologists' licensing laws, don't they? So while there are different titles, in many states the functions overlap. If I'm engaged in life coaching or even executive coaching, and I'm a licensed psychologist, my board, and boards I think in pretty much every jurisdiction, will say, gee, this looks like the practice of psychology, so Dan, you're practicing under your license here. If I'm working where I'm licensed, or where Stacy was just talking about, any state where I have PsyPact or temporarily, not a problem, okay, if it's permitted in the other jurisdiction. There's no prohibition on coaching as a licensed psychologist. On the other hand, if I'm defining myself as a coach, not a psychologist, one will not find state laws or regulations requiring any kind of credential for a coach. There are professional organizations, but they do certifications. It's not a regulation, right? And if I don't use a title as a coach, if I don't use a title as a psychologist, I identify as a coach, I've kind of addressed half of what the licensing laws talk about. Typically, coaching and defining oneself that way is lower risk with licensing boards, because if a licensing board gets a complaint against a coach, let's say I'm coaching in Utah and the board gets a complaint, they're going to say, well, we don't regulate coaches and we can't do anything about it. It is possible, however, for a licensing board to issue what's called a cease and desist notice, or to even refer a coach to a district attorney locally for misdemeanor prosecution for practicing psychology without a license, if indeed the functions overlap significantly. Again, it doesn't happen very much. There are a number of lawsuits around the country against, rather unprincipled coaches, and they're a minority to be sure, but you'll see lawsuits in many different places. But it's relatively rare for a licensed licensing board to act. And partly because the coaches are trying to distinguish themselves by saying, I am a coach. But because of the overlapping functions, it's important as a licensed psychologist, as many of you are here, to know that boards could be more likely to view us as engaging in that practice. So distinguishing between these two roles is not so easy, okay? In order to do that, the best possible way, as our wonderful Eric Harris and Jeff Youngren put together in their description a while ago, it is safer and probably more effective to make sure that your clients have a reasonable perception that you're coaching. So have a coaching contract rather than a therapy contract or informed consent. Have the subject matter be future and goal oriented for enhancing skills as opposed to past oriented around, for example, things like trauma. Don't use standard interventions like EMDR or CBT or EFT, and choose carefully the clients you're working with. More vulnerable clients who have more psychological problems are likely to be riskier, even with a coach. Market carefully. You can't bill health insurance, and be able to demonstrate, Stacy said this, I said it before too, your competence. For example, getting a coach certification, document your rationale. So as it relates to practicing across state lines, Liesl, if you are a coach, you're not representing yourself in any way as a psychologist. You don't need to have a license in the other states or be a SIPAC member with an APIT and e-passport. You don't need to be getting temporary licensure. If you're going to practice under your psychology license, you would need one of those three. If you clearly differentiate yourself with marketing and contracts and selection of clients, most states will generally not regulate you. A caution though, states use what we call the duck test that we've joked about among ourselves, only half joking for quite a while. If it looks like a duck, quacks like a duck, and we have a psychology license, boards are more likely to act to restrict or punish practice if we are doing it illegally. That said, it is a pretty low risk activity, and especially if you're doing organizational and executive coaching, though the definitions of functions may overlap with some states, the risks are lower because of the population you're working with, the focus, and the context.
Yeah, great. Thank you, Dan. Again, really good information, and I'm sure we'll have a chance to unpack it momentarily. Stacy, I'm going to turn to you, and I am noting a little bit our time here, so we do want to turn to live questions in just a moment. But first, I want to get your thoughts on documentation, because that's the other big area we've been getting lots of calls on. And in particular, looking at that balance of, needing to document for ethical reasons, for legal reasons, and for other reasons, clinical care, et cetera, but balancing that need for documentation with also the responsibility to protect patient privacy, especially in really sensitive or high-risk contexts. So can you say a few things about what a clinician should maybe think through in that respect?
Of course. As you said, there's those professional, ethical, and legal responsibilities to keep and maintain records that document our work. I just to take a step back and kind of start off with just in general records, I think it's important to be factual and honest in our record keeping. You want to consider the nature of your practice. Records in a forensic practice versus a family practice versus an individual private practice may look different and may impact how you write notes, who gets access to notes, etc. The practice setting you're in will also kind of have implications for that. There are a lot of organizations that are going to want you to write a specific note. That's how you write it. Whereas in private practice, you might have more flexibility for how you want to write the notes. HIPAA, of course, we've talked about that numerous times, is sort of the gold standard right now for patient access, patient protection. HIPAA is a big fan of sort of minimal records. So you want to make sure that you have the information in the record that's going to assist in providing treatment and continuity of care, establish medical necessity and adequacy for insurance reimbursement, defend against any accusations that might come through in the event of a complaint or an audit, and provide the patient with an understanding of treatment. So this just means that you really want to kind of have a clear record. It might not be 20 pages for each session. Maybe you can do it in 2 pages, that sort of a thing. The minimal, you want all the information, but maybe limit it a little bit. Because under HIPAA, if there's a release, it's the minimum necessary that you would release. A caveat to the minimal record is any cases where there is a lot of complexity or high risk level is associated with the client. In those instances, you would want a more detailed record, which documents any risk assessments or other pertinent information you have done. Laws that we want to be aware of that impact patient privacy, HIPAA, the privacy rule, which generally patients can determine who they want their records to go to. Generally, records are only released with the authorization of the patient or parents and guardians in the case of some minor patients. Patients are allowed to access their records as well, so consider using less abbreviations and avoid judgmental language. And you also want to consider state laws, how your state laws might impact the privacy or the ability of patients to get access to their records. We talked a little bit about insurance requirements so that you can stay in compliance with the information. You making sure your records justify that medical necessity. So then kind of getting into that deeper question of what about records that have that more sensitive information, gender affirming care, disability statuses, abortion, mandated reporting. It's really important as providers to be able to document in a truthful and authentic manner in compliance with the laws. So you're going to want to discuss with patients potential issues. You're going to want to have a very well drafted, well thought out, informed consent process that of any issues that may arise. In the instance of gender affirming care, it may be talking also with the patient about how they wish to be referred in the record and how maybe they need to be referred because of insurance purposes. Because, maybe they have decided they were going by these pronouns, but their insurance is still under their birth name, things like that. And so you got to really have those clear discussions with individuals. Texas has a child abuse reporting law for gender affirming care. So if you're to touch upon cross jurisdictional, if you are a provider in Texas, you might be aware of this. If you are working into Texas, you need to be aware of this, and that should be in your informed consent. You just need to make sure that you're up to date on the information and laws. The big thing is just making sure that the patients remember that they generally control the access to their records, with the exception of court orders or sometimes like police or law enforcement duty to protect cases or a coroner. You're always going to want to ask for the legal basis to release information. It's our job to try to protect that information without the patient's authorization. And you can't go back and change. We've had some people call and they are like, you know what? You diagnosed my child with autism. I want it erased. I want it gone. Unfortunately, we can't do that. That would be fraud. And so we need to kind of talk with our patients about that. And that's part of the informed consent as well. And patients can maybe do addendums if they would like an addendum to their record. We can make those things, dated. We're not changing things, we're adding. It's just really important that we it all comes back to really, for me, the informed consent and making sure that people are aware. We want them to come in and get the support, but we need them to be aware of what state laws and current issues might be going on.
Terrific. Again, great information. Dan, any quick additions before we start in on the live questions?
No, why don't we dive in?
Okay, terrific. Actually, I want to just quickly note there was someone who was asking about which states are not SIPAC states. And I wanted to note, I sent to our team, they're now at some point here going to upload it into chat for you, the link to the SIPAC map, because you can go straight to the SIPAC organization and it'll show you a map of all the states that are members and the states that are not. So just to put that out there. Okay, so the first question, this sort of gets at multiple roles, but is a little different than what we've discussed so far. So the question is, I'm planning to offer mindfulness meditation classes as a teacher, not as a psychologist. If I don't introduce myself as a psychologist and I tell every participant at the beginning that we will be working as a class, not forming a clinical therapeutic relationship, would that be okay? Dan, maybe I'll start with you on this because it's a little bit akin to the coaching and distinguishing roles.
Yeah, it is. It is. So if you stay on the educational side of the street, you're generally going to be safer. Introducing yourself as not a psychologist, um, and doing the education. Where this gets a little bit edgy, though, and you're right, Lisa, it's a bit like coaching, is if with the class you start doing interventions with people. So let's say you're using a now relatively well-known mindfulness exercise that's been developed in cognitive behavior therapy. Remember the duck test. So the more it's informational, the more it has to do, for example, with very traditional mindfulness practices, whether that's in Catholicism or Buddhism, whatever it may be, the less problem you're going to have. Again, educational, pretty safe. Interventional, not as safe.
Yeah, that's a great point. And I think sometimes it comes up mostly when participants or students ask questions, right, Dan? That if someone says, oh, hey, how do I meditate? That's one thing. But if someone says, gosh, I'm experiencing a lot of anxiety, please tell me what I do with my anxiety or my sadness or depression, you might veer more into that therapy land than meditation. So.
Yeah.
Okay, great. So this is let's see. I want to, all right. This is a Medicare issue, but it's not, it's more just sort of generally, anyhow, let me just read you the question. Medicare, someone received Medicare email this week. How are they going, that Medicare is supposed to be, is going to be more flexible in client provider care, but this clinician's concerned that that's not the case given their requirement for in-person once a year meetings with current telehealth patients, and that they've redefined sort of how home, meaning that the client has to be at home during telehealth and can't be at work settings, et cetera. I wonder here, first of all, if one of you, and I'll let either of you decide who wants to take this, one of you can just clarify what the situation is. I know there's been a lot of back and forth on, telehealth is covered, it's not, what, because the rule changed there. Can one of you just clarify that? Because I think that will address this answer most directly.
Stacey, I'll take a first stab at it, okay? So many of you know that for Medicare providers, after the end of October, we were stuck with, does the exemption from the requirement to see someone within the past 6 months, does it still exist? Once the Congress came back into session, they extended it through the end of the year, and there's a bipartisan approach to try to have it extended further. So I think for those of us who've been seeing clients under the previous exception, not being required to have seen somebody within the past 6 months, there's a good likelihood that that exception is going to continue. Around the yearly requirement, that hasn't changed. However, there is more flexibility in that. If you and the client agree, or patient agree, that it would be more problematic to meet in person, you can document the reasons why you did not meet in person on a yearly basis. Otherwise, you do meet in person at least once every 12 months from the time you've started. That's the major change. Those are the two major things that I'm aware of vis-a-vis the changes. Medicare's supposed increased flexibility, at this point, I think we're going to just have to see what they describe specifically about what that means, because it's not clear in my mind what I've read so far about, are they implying that they're going to reopen? It could be physically anywhere. It could be, it's not clear in my reading thus far.
Yeah, I agree, Dan. And I think, as always with this, as you say, it has been back and forth. So staying tuned and paying attention to what changes. Right now, it's the way it is through the end of the year, but the end of the year is almost upon us. So this could change as of January, right? And it's just a matter of keeping up to date on that. Thank you. So Stacey, I'll toss this one to you. And this is a SIPAC specific question. So do you have to be in your home state while providing cross-jurisdictional teletherapy into a SIPAC state?
Yes. Short answer, yes. You can change your home state. So if you are traveling, you can theoretically change your home state to wherever you are, as long as you are licensed. Actually, I'm not sure. We don't have to be fully licensed there. I think you have to be licensed, but you can change. Yeah, clarify.
Yeah, let me just jump in there. So Yeah, if you are, in order to change your home state, you have to be licensed in that other
Licensed
state.
in that state. Okay, that's yeah. Which is where SIPAC gets confusing. But you can change it. So let's say you are licensed in um Maine and Vermont. I think there are states that are in SIPAC. If you travel, you can change it. You just need to make sure that your home state reflects where you are. And then you can still do cross-jurisdictional in other SIPAC states.
Correct.
Yeah.
But if you go into a state where you're not licensed, then you actually then can't practice under SIPAC at all because you're not in your home state. Right. Dan, this one, thank you, Stacy. This is going to go to you to clarify. You mentioned not to use AI online. I know what you meant by that, but can you clarify that a little more? Because we've had a
Sure.
question on that.
Yeah. So the general public artificial intelligence systems that are out there for free, there's two things. One is you have to remember what my grandmother said. She said there's no such thing as a free lunch. So what you're giving when you use AI or any kind of public free process is you're giving information. Okay. So if you use AI like, and I'm not picking on any particular one, but any of the open ones that you can get online, and you use it for identifiable information or something that could be identified for patients or clients, that's what I'm saying. Do not do that. Okay. Can you ask it a question about, gee, is it a good idea to do a practice this way or that way? Sure, of course. Other thing that I would really strongly encourage, though, is any answer you get, fact check it. Because what's fascinating is I was just reading an article this morning on programs that are developed, AI that's developed for specific specialties in medicine. And one of the critiques is that they tend to give the same answer with people with diagnosed with similar problems, but with very different situations. So it tends to be too generic. In addition to which, it plain old hallucinates and makes up answers to questions and has bias built in. So if you're going to use those bigger systems, don't disclose any private information. Don't ask it to write a report for you, because those reports are going to have information that an aggregator bot can put together and go, oh, this is Dan Taub in Northern California, without much difficulty at all.
Right. And yeah, just to underscore that last point, in case folks aren't as familiar with AI, that even if you quote unquote de-identify, as we normally would in our field, if you de-identify it in the normal way and put that into one of these open AIs, the AI is so powerful and has so much data, as Dan pointed out earlier, it can actually re-identify that person. So our normal strategies for de-identifying are not sufficient in these open AI systems. So really, as Dan said, do not put patient information, de-identified or not, into these open AI systems because it's too much of a privacy concern.
I'd like to reiterate also the potential for bias, right? Because these are open and it's not just mental health providers that are using them. It's not just, the best of society and the worst of society, right? There's a lot of information that gets put into there. So you really do, that double checking is a big thing because you just don't know what you might get out. You might put in the prompts that you want to use. You got to be careful about the prompts.
Yeah, and I think, for those of us that may want to use AI, to your point, I mean, I think we actually have to build in a system for how we are going to identify bias and how we're going to ensure that that's not impacting our decision making or our record keeping. And that's a little bit complex. I think there are ways to do it, but it's one of those pieces. I'm glad you underscored that, Stacy, because I think if we're going to start to use this, we have to really make sure that we're protecting clients in that way as well. And the last thing I'll add, I know the three of us have talked about this before, but is that AI should always be seen as sort of a collaborator or a co-pilot, never, ever in the lead, right? You always, like Dan said, it makes mistakes. It can be blatantly wrong, even though it will sound very accurate. So really important that you are firmly in charge, you, the clinician. So Stacy, another question on teletherapy. I'm going to turn this back to you. So regarding teletherapy, what about a psychologist licensed in, say, Florida or Georgia? providing teletherapy to clients located in those states, but the clinician is out of the country, say in Mexico. So basically here the question, it's not so much about the states in particular, but can a clinician be out of the country practicing back into the states where they are licensed?
So in those instances, it comes back to the licensure. So if you are in Mexico, if you are in another country, you're going to want to see if you should be getting some sort of temporary practice, potentially looking in to see if they have any, if they regulate their practice. The patient being in Florida, if you're licensed in Florida, the Florida licensing board is going to be okay with it. The question is the other country, how are they going to feel about you providing therapy within their country into another state, because you are the one providing. So you need to kind of be aware of, like we had said, the jurisdictional rules and the temporary practice provisions.
Great. Yeah, Dan, any additions there?
Yeah, if it's under SIPAC, the answer is no. Right. So if I'm in Mexico and I'm a SIPAC member and I'm seeing clients in Georgia under my Florida license, I can't do it. If I'm doing it under my Georgia license, just like you were saying, Stacy, and Mexico doesn't object, then it's generally going to be considered okay. All of the other cautions you offered before, Stacy, would still apply. Is this appropriate? Can I do this long distance? All that sort of thing.
Right. And in that latter regard, I think it's important too to always remember to have, if you know, it's a good idea to have a backup, a colleague who can provide backup in those states, especially if you're out of the country and the time zones are really different and a client has a crisis and maybe you're asleep and they wouldn't know. And, you know, it can be, there's a lot of complexity. So thinking through and having some coverage in that state while you're away is a really prudent thing to do. Dan, some other additional questions here on AI. First of all, we do have a question about whether or not we have an AI-informed consent template, and as of yet, we do not, but we will make note of that request and potentially work on that. But one question here is, can AI really ever be safe to use? So I'm going to give that broad question to you, as well as a super specific question, which is, can or does Bastion GPT provide sufficient safeguards?
So I'll answer the latter question. I can't answer that question. Okay. We can't endorse, and I can't tell you yes or no. Do I believe that AI could ever be safe enough? Yeah, I do actually. And I think what we're going to see is an increasing number of programs that address many of the issues that I've raised, and I'm not by any means, I'm reflecting what's out in the literature. I'm not coming up with these ideas myself, that will address those because they want to be successful in being able to provide these services to a wide range of healthcare and mental health care professionals. But as it stands right now, it is kind of the Wild West. What we're seeing is a tremendous infusion of programs, many of which have never been researched. Many of which I actually ran across one last week, which will go nameless, where they said we are HIPAA compliant. And when I dug in deeper, they weren't willing to sign a BAA. So that's not HIPAA compliant. And that doesn't help me or you. So the general idea is, I think, yes, we will. And I don't think AI is going away. There is an enormous amount of, literally a deluge, a tsunami of information about AI coming at us right now. And people very concerned about it, but also I do think there are very good reasons to think that it is contributing and can be a real help when properly used.
Yeah, I agree. I mean, as you know, Dan, I've sort of been digging deep into this AI stuff. And I think we're right now, like you say, Wild West, but we're right on that cusp, right? Where it will eventually become safer. Will it ever be 100% safe? No, because nothing electronic is 100% safe, right? All of our EHRs aren't 100% either, but I think it is moving in that direction. I agree with you right now, right? There's some lack of clarity. And so it's essential that if you're going to make use of AI, that you do a lot of homework and really understand it and make sure you're using it in a safe way. Stacy, anything you wanted to add on that before I toss you another question?
No, I think you guys covered it. It's just, I want to say, remember EHRs when they first came out, right? They were a nightmare, and now they're really some really good ones out there. So I think technology moves. It sort of becomes more protective, but you got to be really cautious and be prepared to wait for that.
Mhm.
Lisa, just one other thing I want to add, which is everybody, please keep in mind there are no regulations, no body regulating AI in the United States. It is not governed by the FDA because it's not considered a medical device. So it truly is, it's not even any kind of regulation, and the feds are pushing towards not allowing states to regulate it, even though some, like Illinois, have outlawed its use in some circumstances. So it's again somewhat relevant to what Stacy you were talking about, that you have to look at the state laws right now, and it's a very quickly moving target. I don't even know what it's going to look like in a week, never mind 6 months.
Right, I agree. And that makes it both exciting and worrisome, Dan.
Yeah,
That's
yeah.
your last point there. Okay, so Stacy, I'll turn this one to you. If, take for example, a clinician who's doing periodic one-time evaluations into various different states. The question here is, can they make their informed consent general and say that the evaluation will be done in accordance with state licensure law, rather than having specifics about each state? They say it seems impossible to make 43 different informed consents for a one-time evaluation. Can you give us some thoughts on that about informed consent?
Or, I mean, that's possible. But my concern would be that if something went wrong in one of those states, that a licensing board might not like that boilerplate language, right? I think, it's really important to be mindful and aware of the state laws and make sure that we know our patients are aware of the state laws. And saying that this informed consent complies with Illinois state laws, your patient might not know what that means. And so you're still going to have to explain a little bit about what mandated reporting and things are. So I suppose it's possible. I wouldn't recommend it. I know it's onerous. I get it. You can develop a template maybe where you can plug and play in those sorts of things, or maybe you try to limit the number of states that you practice into so you don't have to have 43, 53 different forms. But I really think to minimize risk, it's important to know and be able to explain to the patients how the laws in that state where the patient is might impact the assessment, your work with the patient, any mandated reporting that might come out of an evaluation, things like that. I would strongly suggest it needs to be state specific.
Yeah, I really agree. Dan, thoughts on that?
No, I agree.
Yeah, I agree. And because I'll just add, I think you're not really giving informed consent if you make a general statement, right? You would never make a general statement like that in your state. So I think, I think it's not true informed consent if we're not giving some of the details. Okay, so Dan, this one I'll put to you, and we've gotten this in various forms, I know, on the advocate line, but basically any guidance for house psychologists who are practicing in multiple states, what they should do about some of the tax implications, because this can get confusing, right?
Yeah,
you know exactly where they're headed. So
yeah, absolutely. So this is a complex area, and it's complex because states will tax different goods or services if they're delivered in that state. It may or may not be that the state has actual jurisdiction over you and can collect those taxes. But as much as this is actually related to, Stacy, what you were just talking about regarding informed consent, one has to know about the rules and laws regarding state level taxation in the state into which you're practicing. And you may have to pay income taxes in a different state. This will depend on a few different factors, the state regulations or laws. If you have a business entity in that state, also what's called sufficient contacts. Do you have a lot of business in that state or one time? But I know, for example, in one state in particular, all you need to do is sell one thing one time and they're going to apply a sales tax. It doesn't matter. And many of you have encountered this now when you're using the large platforms that are purely sales and marketing platforms, where they're adding state sales tax to each purchase, depending on the jurisdiction into which or from which the good is coming. Same goes for services where there may be taxes. But here, it's mostly about income tax issues. So, related to the idea, do I have to do this in 43 different jurisdictions? If you're going to take a step into each of those SIPAC jurisdictions, you have to know, according to SIPAC, the laws in those jurisdictions, and you have to abide by them, which makes it super complicated if you just dive in. So we generally recommend go slow. If you can do it, one or two other states to begin with. Learn what you need to learn. You may need to get a legal consultation from a local attorney in the remote state to understand tax implications, to understand, do I indeed have to report elder abuse or vulnerable adult abuse if I'm not working in a large setting like a facility? And to circle back, to not get too far from the taxation question, do I need to be attentive to and track how many services and how much income I made in that state?
Mhm. Great. Yes, there's no perfect answer, but you answered that very well, Dan. Stacy, let me turn this one back to you. And I know it's a little bit redundant, but it's good sometimes to repeat because these are complex issues. So here the question is, they say, I don't plan to provide interjurisdictional practice, but want to clarify. Oops, sorry, it just moved on my screen. Uh-oh.
Oh.
Well, maybe we won't answer that. It just disappeared all completely off my screen. Okay. Well, we'll try to come back to that. I know we're also coming up on the deadline here. Let me try to fit in just a couple quick ones. Stacy, I'll come back to you, but I just wanted, this one is on AI, so I'll let Dan handle it to start, and then you can jump in. But Dan, can you expand on AI that is for notes and report writing? Here they want to know, what are the simplest and most private ways to do that? I know you can't answer that exactly, but what should someone think through on that issue?
Well, look carefully at, again, the terms of service and the privacy policies of your note-taking AI, whether the information that is getting generated is being stored on your local devices or it's being stored in the cloud. If it's being stored in the cloud, with which businesses and who has access to it? Is it secure? Okay, so those programs, and again, there are lots of advertising for those programs in themselves may be good, but maybe not. And the questions about privacy, about storage, about do they keep the recording? Do they destroy it? Do they keep the transcript? If so, where is it destroyed? Is it destroyed securely? It's again, the privacy considerations. So those two areas that I touched on briefly in the introduction are the areas you want to dig into deeply.
Mm-hmm. Great, thank you. And Stacy, this one I'll turn to you, having to do in part with HIPAA. So are providers in different practices, hospitals, outpatient, et cetera, required to get signed ROIs, release of informations, to share patient information, or are all mental health providers allowed to share information when asked related to medical or mental health care?
It's a little bit of a complex question. If you are part of a treatment team, and like in a hospital in a treatment team, generally the informed consent that they have, they're going to allow for the sharing of information for treatment and payment, and healthcare operations. Now, sharing, let's say you are a private practitioner and you've got a psychiatrist who reaches out and says, I'd like to talk to you about so-and-so patient, but this is not a psychiatrist, or anything. You're going to want to get an authorization from the patient for that. So if there's no known connection. So it really kind of, I think, to simplify it, and this is too simple, is if you're part of a treatment team, then you don't need to get that authorization potentially. There'd be an informed consent. Patient would know that the treatment team is sharing the records. If it is somebody outside of your practice, it's good practice to get that the authorization, the release.